UKSC against Secretary of State for the Home Department.
Yes, my lords, I appear with my learned friend Kate Marcus for the appellant in this matter, and my learned friends Robin Tam, QC, Tim Ike, and Rory Dunlop appear for the respondent in this matter. My lords, I hope your lordships have had a speaking note in response to the respondent's case. And in addition, there are two short notes which we have had placed on the table before you. One is an analysis of three of the first instance decisions post-JJ, dealing with the question of 14 hours, 16 hours, and the circumstances in which that constitutes a deprivation of liberty. And the other is a short note in response to my learned friend's point about person-specific factors not being taken into account. And that's headed supplementary note on the subjective-objective approach. My lords, in that we've attempted a definition of the subjective factors that are to be discounted, and also both sides have attempted a definition of the word concrete, as in Guzzardi saying you have regard to the concrete situation of the individual. My learned friend's definition is that it's something that is not volatile and ephemeral. We say that that is far too abstruse, and that all that was meant in Guzzardi when it was said you look at the concrete situation of the actual individual is that you don't look at the formal categorization of whether he's in prison or not, but the actual situation that they find themselves in, and the combination of factors. So, my lords, that's the broad summary. And if I could take your lordships to the speaking note and to the propositions set out in the introduction. Could I first just, as it were, give the broad outlines of our case and then deal with it in some greater detail. But our first submission, as set out at 1.1, it is that Mr. Justice Keith's judgment was correct. It accords with the principles laid down by the European Court in Guzzardi and by the House of Lords in the trilogy of cases JJ, MB&AF and E. And in essence, we say that what those cases indicate is that you look at the concrete situation of the individual, you look at the measure restricting liberty, you look at its nature, purpose and effects and manner of implementation, and that a combination of factors can render what would otherwise just be a restriction of movement into a deprivation of liberty. And we say that that test was applied perfectly properly by Mr. Justice Keith in this case. The proposition at Roman 2 is this, that a control order containing the core element of a curfew of 16 hours a day is perfectly capable of amounting to a deprivation of liberty when combined with other significant restrictions. And just at this stage, can I just put this, that was implicitly recognised by Lord Bingham in JJ at paragraph 17, and without going to it in detail, in essence, Lord Bingham at paragraph 17 there said that it was not possible to draw a bright line and disavowed the attempt to say whether it's 14 hours, 16 hours or 18 hours that is the line. But clearly we know from those three decisions that the two cases involving respectively 12 and 14 hours were found not to constitute deprivations of liberty. But the case of JJ, which involved 18 hours, was found to be clearly on the deprivation of liberty side of the border. So that leaves, as it were, the question of what about between 14 and 18 hours. Baroness Hill herself also said that it was inappropriate to draw a bright line in that grey area in between, and that's at paragraph 63. And I will of course, take your lordships in detail to it in due course, but both of them rejected my Lord Brown's bright line of 16 hours, which we understand to mean that my Lord Brown intended clearly to say that 16 hours curfew would always be acceptable, and that's at paragraph 105 B to C.
Were Lord Bingham and Baroness Hell simply drawing the bright line at 18 hours? You said that between 14 hours and 18 hours there's a grey area. It would seem to be implicit that at 18 hours you do come up against a bright line.
My Lord, yes. Yes, at 18 hours, all three of the majority were indicating that at 18 hours, it was just, can I just put it this way, it was just too long. So, but in between the 14 and 18 hours.
So is 14 hours another bright line?
Not entirely, because, can I just put it this way? In the case of AF, which was the case in which it was said that 14 hours was not a deprivation of liberty, there were other factors, such as he was living in his own flat, such that it may be that if you are totally removed from your own area and not living in your own flat, but removed from that and from all normal social intercourse, it could be that 14 hours constitutes a deprivation of liberty when taken in conjunction with all those other factors. After all, in Guzzardi, the curfew was, I think, only 10 or 11 hours, but the combination of the other factors made it a deprivation of liberty. The fixed polls, the clearly fixed polls are 12 and 18 in the context of control orders. The grey area identified by Lord Justice Carnwath in this case itself was between 14 and 18, but we wouldn't want to concede that 14 could never constitute a deprivation of liberty if accompanied by other serious restrictions or severe restrictions on liberty and social isolation. But for the present purposes, obviously, we're focused on the question of 16 hours. And it was also recognised by all three of the judges of the Court of Appeal in this case. If I could just take your lordships briefly to the summary of that at paragraph 22 of the case, which is page 8 of the case.
So is this your speaking note? Or?
This is in the written case itself. In the court volume, the written case itself. And your lordships can see there that at paragraph 22, it's page 10, it's set out. All members of the Court of Appeal in the present case agree that the case law establishes the following. A, the core element of confinement is a starting point in any consideration of deprivation of liberty. B, a curfew of 18 hours or over will always amount to a deprivation of liberty. C, a curfew of 16 hours is capable of amounting to a deprivation of liberty. And D, whether a 16-hour curfew is a deprivation of liberty in any particular case will involve taking into account a range of other factors. So there was agreement, certainly, in the Court of Appeal between the three judges on that issue. And against that background, if I can take your lordships to the third proposition, we submit it was entirely reasonable for Mr. Justice Heath, in his judgment, to take the view that the combination of three factors made this a deprivation of liberty. And those three factors were, first, the 16-hour curfew, secondly, the forced relocation of AP from London to a place 150 miles away, with consequent difficulties of access to his family, and thirdly, the prohibition on pre-arranged meetings with others. I think it might just at this stage help if I just took you to that passage very shortly to indicate how he put it. It's at page 58 of the appendix, part 1. And he sets out the relevant tests at paragraph 94 and 95, indicating that there's no bright line, that the test is an objective one, and at the top of page 58, many relevant factors must be taken into account, such as the nature, duration, effects, and manner of execution or implementation of the measure in question, but the starting point is the length of the curfew, the core element of confinement, and then that social isolation is a significant factor, especially if it approaches solitary confinement during curfew periods. And then he deals with, at paragraph 95, thus, although the paradigm examples of deprivation of liberty are detention in prison and house arrest, deprivation of liberty can take many other forms, and the court's function is to look at the package of measures as a whole. To these principles, though, I would add two more. First, Lord Brown commented at paragraph 108 on the explicit reluctance of his colleagues to suggest the point at which curfews would, by virtue of their length, involve the deprivation of liberty. He went on to say that, in his view, a curfew which did not exceed 16 hours was insufficiently stringent as a matter of law to affect the deprivation of liberty. And then, secondly, a sense of social isolation would be felt particularly acutely where the control person was required to live in an area unfamiliar to him, in which he had no family, friends, or contacts. If he was cut off from his old haunts and acquaintances, his ability to lead any kind of normal life during non-curfew hours as well as curfew hours would be affected. See, for example, Lady Hale at paragraph 61. I would characterise it as a form of internal exile. And he does find that in this particular case, it is a form of internal exile. He goes on to deal with the question of solitary confinement in the community, drawing on the language of Mr. Justice Mitting in paragraph 96, but noting that in the AH case, a 14-hour curfew was not sufficient, although it was very close to the borderline. But, of course, there was no prohibition there on him meeting anyone else, whether inside or outside his flat, whether by arrangement or otherwise. And it was a different situation in terms of where he was living. But then, against that background, paragraph 97, it is the combination of the equivalent of house arrest up to the maximum period identified by Lord Brown, that's to say 16 hours, and the equivalent of internal exile, which makes AP so socially isolated during the relatively few hours in the day when he is not under house arrest, coupled with his inability to make even social arrangements because pre-arranged meetings are prohibited, which lead me to the conclusion that the obligations imposed on him fall on the side of the line which involves the deprivation of liberty rather than the restriction of movement. And just pausing there, that we respectfully submit is the ratio, that sentence. And we say it's entirely correct. And then he goes on, as Mr. Justice Mitting said in AH, this is a matter of pure opinion, which does not permit detailed elaboration. So he goes on to elaborate, and then he says, but had he remained in London, so that he could still see and be visited by his mother, his brother and his sister's 3 children, my view would have been different. And that is the sentence that has been focused on by both the majority in the Court of Appeal and my learned friend in his attack. We respectfully submit that all that's being said there is that had he remained in London, where he was being regularly visited by his family, the situation would be different. And that one shouldn't attach too much meaning to the word could still there, because at paragraph 88, he's already said it's difficult but not insuperable. He could visit, he could be visited, but there are big problems about being visited by his mother, his brother, and the children obviously don't visit necessarily, but then coming up with the mother. That's to say, his sister's children. But and looking at that, we respectfully submit that that was entirely correct at paragraph 97, and that the great focus on the words could be visited, it has attained an exaggerated importance in this case. What he's saying is, if you're sent 150 miles away, where obviously it's more difficult to be visited by your family, if you've got no ability for pre-arranged meetings, and if in addition you've got 16 hours, which is recognised by all to be at least on the very borderline of what's acceptable, you put all those three together and you've got a deprivation of liberty. And we submit that that's an entirely correct analysis, which is in accordance with the authorities. And only if one were taking the position that my Lord Brown took in the case of JJ, that 16 hours would always be acceptable, would it be the case that there'd be an error of law. But the Secretary of State is not contending in these proceedings for the proposition that 16 hours is always acceptable. He accepts, as indeed the Court of Appeal accepted, that 16 hours is capable of amounting to a deprivation of liberty when accompanied by other severe restrictions. And we say that the restrictions here were very severe. Well, so that's the position in respect of Roman 3. And at Roman 4, we say that there was no error of law in Mr. Justice Keith treating the relocation and consequent restrictions on access to family as capable of being decisive in turning the overall regime into a deprivation of liberty, even though they were found, those restrictions, to be Article 8 compatible. And well, that brings us on to, in very brief summary, the error of the Court of Appeal and the Court of Appeal majority. Can I just, again, showing you it going to the heart of it very briefly, take you to the judgment of Lord Justice Kay at page 14 to show you the key passage. And it's really from paragraph 30 to 32, but principally in paragraph 32, but just taking the context. Paragraph 30. In the present case, Mr. Justice Keith concluded in paragraph 97 of his judgment that it was the combination of the confinement and the degree of social isolation or internal exile, coupled with AP's inability to make social arrangements, which caused him to hold this particular control order to be a deprivation of liberty rather than simply a restriction of movement. The key to his reasoning is clarified by the final sentence of paragraph 97, and then he quotes, "Had he remained in London so that he could still see and be visited by his mother, his brother and his sister's 3 children, my view would have been different. The question now is whether by treating the effect of relocation on family visits as the decisive factor, the judge fell into legal error. In my judgment, he did. The reasons for my conclusion on this point are twofold. First, as a matter of fact, AP could still see and be visited by those members of his family, although there were logistical and no doubt financial difficulties. I base that on the judge's finding, paragraph 88. The fact is that he could, the fact is that they could visit AP en famille on Sundays, as well as the other days of the week outside the school terms, and they could travel at off-peak times to get the advantage of lower fares. On that basis, the judge erred in law in treating as decisive something that was at variance of his earlier finding of fact." My Lord, we say that that's a somewhat, if one reads a somewhat unfair point, if one reads the judgment as a whole, Mr. Justice Keith was plainly aware of the fact that only a few paragraphs earlier he had found that it was possible, though difficult, to visit. The problems were not, there were considerable problems, but they weren't insuperable, was what he found. And here he's merely saying, had he remained in London, where he was being regularly visited, without difficulty by his mother, his brother and his sister's 3 children, his view would be different. And to put all the emphasis on that word could, when he plainly knew that the position was he could be visited, but only with difficulty and with far less frequency, is in our respectful submission to adopt an over-analytic approach to the judgment. He plainly knew the position. He had analysed it very carefully in paragraphs 87 to 88 and said it would be difficult but not insuperable problems.
Isn't he just saying in paragraph 97, Mr. Justice Keith, so that he could, brackets, without the not insuperable difficulties to which I've referred in paragraph 88,
Yes.
close brackets and then go on?
My Lord, yes, could frequently or easily. That's all he's saying. And to base it on this is really a great disservice to the judge. One has to credit him with the intelligence to realise the finding he just made of paragraphs 87 to 88, which was the ratio of his finding on Article 8. And therefore, it's could easily or could regularly or could frequently is clearly what he's saying. But his ratio is the first sentence where he says it's the combination of 3 factors. 16 hours, a long way away, a kind of internal exile, and no possibility to meet anybody but the family who find it difficult to visit him, other than by pre-arrangement. My Lord, we totally respectfully agree with your Lordship's interpretation. That's a sensible interpretation. And in any event, the Court of Appeal shouldn't be getting involved in this kind of textual analysis when it's broadly correct. Lord Justice Conworth made the point that there's got to be some degree of respect for the value judgment, and that's what all the authorities say it is, the value judgment made by the judges of first instance in what Lord Justice Conworth described as these sensitive cases. So if one puts that aside as a somewhat sophistic or over-analytic point, what is left? What is left is paragraph 32. Secondly, having concluded that the core element of confinement, the 16-hour curfew, was otherwise compatible with Article 5, the judge was wrong in law to permit the issue of family visits to tip the balance. He had earlier concluded that relocation away from London was otherwise necessary and proportionate to ensure that AP does not maintain personal contact with those of his associates in London who are or may be Islamist extremists. It seems to me that then to allow that to be trumped by what is really an Article 8 rather than the core Article 5 consideration amounted to an error of law. And we say that's just plain wrong. It's been accepted in all the authorities that the fact that the restriction also involves Article 8 doesn't mean that it can't be relevant to Article 5. That's to say, it's one of the factors that you take into account, that your access to your family is restricted, or that you're suffering some form of internal exile. And though that can be challenged under Article 8, it's still relevant to Article 5. Now, if it's relevant to Article 5, it clearly, in some cases, can be decisive. It's just, that's the simplest proposition of basic administrative law. You can't say something's relevant, but it can't be decisive. And yet, that's exactly what they are saying. You can take it into account, but it can never be decisive. And if one looks on to the assenting judgment of Lord Justice Wall, he makes exactly that error in our respectful submission. Paragraphs 38 to 39. Paragraph 38, in reaching the conclusion that the Secretary of State appeals should be allowed, I would like to make it clear that I do not resile from anything which this court, of which I was a member, said in Secretary of State v.E. And then he goes, I note in particular that in Ray, we rejected a submission made on behalf of the Secretary of State that issues which related to Article 8 should not be considered under Article 5. And then it sets out, we do not accept Mr. Tam's submission that because restrictions engage other articles in the Convention, such as Article 8, they should be disregarded in Article 5 context. Evidence relevant to an Article 8 claim, even if a breach of that article is not established, may be relevant on a consideration of Article 5. So they are relevant. Now, then having said, well, they're relevant, he says at paragraph 39, but they can't be decisive. And that's, there is, in my judgment, a substantial difference between taking Article 8.1 factors into account when discussing Article 5 on the one hand, and on the other hand, of treating them as determinative of, or as Lord Justice Maurice Kay puts it, as tipping the balance in relation to an Article 5 determination. In my judgment, the judge has done the latter, and principally for this reason, I find myself in respectful disagreement with him. And then, can I just take you to the last sentence at paragraph 41, because it makes it clear that he says, nothing in my disagreement with the judge should be read as diminishing the force of that proposition. I stress that it is only because I detect an error of law in his approach that I feel confidence to intervene. So the error of law is you can treat it as relevant, but it's wrong in law for it ever to tip the balance. And we say that not only is that not an error of law, the counter proposition which led the majority to reach the conclusion they did is fundamentally wrong. Now, the Secretary of State now concedes that it is fundamentally wrong. He accepts that it can't, that as a matter of law, if a thing is relevant, it can tip the balance, it can be decisive. What he says now is, but they didn't really mean that. What they meant was, in this particular case, it shouldn't have. But that's, if one reads that, that's plainly not what the Court of Appeal is saying. Lord Justice Wall is saying we shouldn't be getting involved in second guessing, but there is an error of law, and the error of law is turning something relevant into something decisive. So if that isn't an error of law, there is no basis to intervene.
But if they wouldn't, if they're relevant but shouldn't have tipped the balance, the conclusion that they shouldn't have tipped the balance is what, a conclusion of fact, is it?
Yes, it's a second guessing, if I can put it, my Lord.
Not an error of principle at all.
No. And it's precisely what Lord Justice Carnwath, who dissented, said they shouldn't be doing, and what Lord Justice Wall said he wouldn't be doing, and that he'd only intervened because there was an error of principle or law. It's because at the heart of this appeal is that what we respectfully submit is a fairly straightforward and basic and glaring error by the Court of Appeal, subject, of course, to my learned friend, that I've tried to take the Lordship straight to it, because we say it really is just, well, we respectfully submit it's pretty obvious that they got it wrong. And indeed, my learned friend doesn't seek to rescue that proposition at all. He says, well, they couldn't possibly have meant what they expressly said. But he's less kind to the judge when the judge uses the word could once and says he clearly did mean what he expressed. But my lord, that being the case, what we then have is my learned friend's new point, which doesn't feature in this ratio, which is that person-specific factors were taken into account and shouldn't have been. But that in our respectful submission, was not the ratio. I should, in fairness to my learned friend, show you that Lord Justice Kay says, he says that paragraph 33, for these reasons I have concluded that Secretary of State's appeal should be allowed essentially by reference to the third ground of appeal. And if one looks back, it's true that the third ground of appeal was something of a portmanteau ground. At page 12, it's at the top of page 12, you can see the third ground set out. Further on the alternative, Chief J erred in law in relying on the inability of AP's mother, sibling and nephew to visit him as the decisive factor. Well, that's what the part that they relied on, that it shouldn't have been the decisive factor, in rendering the control order obligations a deprivation of liberty, as the question whether there is a deprivation of liberty does not depend on the subjective or person-specific impact of the measures on the controlled person. Well, it's the decisive element of that the Court of Appeal majority adopted, and rather than the person-specific element. But we say that in any event, there was no inappropriate taking into account of person-specific factors here. And that's...
Does the Court of Appeal actually touch on the question as to the subjective?
No, they don't, no. So it doesn't arise in it. Really, this is, with great respect to my learned friend's attempt to find an alternative basis of principle on which your lordship should find the Court of Appeal.
He's entitled to do that.
Oh, no, my lord, he is, yes. Well, yeah, yes, he is. But it would have to be pretty plainly wrong, I would submit. But, my lord,
The Court of Appeal doesn't touch on it. The trial, Mr. Justice Keith, although, of course, he cites
AH.
Mr. Justice Mitty, and the second of his principles are listed from the authorities. And that, of course, counsel there is a reference to, I think, Mr. Starmer, now the DPP.
Yes, my lord, yes.
But I mean, does Mr. Justice Keith discuss that aspect?
No, it didn't really. It didn't really feature this subjective objective. It's quite true. It's recited, but my lords, can I just pause for a moment and indicate that what we say this subject, and that's the purpose of this further note.
Yeah.
What we say is that there are really three propositions. The first is that when the language of you look at the objective circumstances is used, for example, in Guzzardi and by Lord Bingham in the JJ case, what they're contrasting is you look at what the position of the actual circumstances of the person, his concrete situation, not his subjective views as to whether he is or is not being detained. Because, for example, in Guzzardi, Mr. Guzzardi got very heated and eloquent on the subject of his conditions and said this is the worst form of incarceration that there has ever been. And it's cited in the judgment of the European Court, paragraph 62. Now, the fact that someone says, I'm experiencing this as a loss of liberty because it's appalling, and I'm getting very angry about it, or very upset about it, or even I have to go and see a psychiatrist about it, that doesn't turn it into a deprivation of liberty. And that's all we respectfully submit that the objective point means, is you don't determine it by what the person who's complaining about the restrictions says he thinks it is, or indeed extreme personal reaction to it. You determine it by looking at the facts. But all the authorities say you do look at the specific situation of the individual and the concrete situation of the individual, and that's Roman 2, the proposition. The judge does take account of the concrete situation of the individual and his family, and that's made clear in Guzzardi, where it says you look at his concrete situation.
But I don't read paragraph 62 as saying what you say at the bottom of page 1. Does it really say that?
Oh no, no, it was just an illustration, paragraph 62, that that Mr. Guzzardi was getting very excited in that case. I mean, in other words, no, my lord, I was only giving that as an illustration. You look at the objective facts rather than what he says about it, because paragraph 62 of Guzzardi, which is tab 24, he was describing. Can I just find in the European Court's judgment?
352.
Yes, 352. Yes, in 352. It's at tab 24 of bundle 3. But one sees there, in support of this, it referred principally to Mr. Catalano's letter. However, the original application, and then one sees a scrap of land. His client, he added.
352.
Oh yes, his client, he added, was being subjected to the most barbarous imprisonment, the most degrading and pernicious incarceration. For the government, these were merely hyperboles and metaphysics employed in the context, but the court considers that they amount to a complaint of a failure to observe. My lord, the only point I'm making is that the fact that someone or his lawyer on his behalf says this is appalling, doesn't turn it into. You analyse the situation and determine whether, in fact, it is. And that's the concession that was made by Mr. Starmer in AH, that you don't have regard to particular a psychiatric reaction or some specific problem, and we respectfully submit that that is the antithesis. And if your lordships have it at Roman 2, concrete, we submit, is the opposite of theoretical. The antithesis is between the actual existential situation on the one hand, and on the other hand, its formal classification or categorization as a matter of law or even philosophy. Where the European Court uses the word concrete, paragraph 92. Paragraph 92, it's page 362 at the bottom. So one sees the court, paragraph 92 starts, in proclaiming the right to liberty. Its aim is to ensure no one should be dispossessed of this liberty in an arbitrary fashion. And then towards the bottom, the starting point must be his concrete situation. An account must be taken of a whole range of factors, a range of criteria such as the type, duration, effects and manner of implementation of the measure in question. And that language of concrete is picked up by the majority in the House of Lords in JJ. But it means that the context of Guzzardi was that the Italian government was saying it's only classic imprisonment, that's to say being locked up in a cell, or something closely akin thereto, that qualifies as deprivation of liberty. And this is a mere restriction of movement. And what was being said is concrete is opposed to the theoretical classification of it in domestic law or in the context of what you notionally require for being confined in a cell. So that's what concrete means. It means look at the actual position and determine, without being bound by some legal category, is this in fact and substance a deprivation of liberty? And indeed, you don't, in conducting that exercise, disregard person-specific features, because in the Court of Appeal in JJ, my Lord Phillips dealt with the hermit argument and said, but I'll take your lordships to it, he said, you don't. The Strasbourg case does not require that you disregard person-specific factors. You do look at the actual individual and the impact on that actual individual. And so we submit that the Secretary of State's argument that you don't look at anything person-specific is simply contrary to all authority. And when he attempts a definition of concrete as something which is not volatile or ephemeral, quite frankly, we respectfully submit that that's meaningless. I mean, what does volatile, the antithesis of volatile and ephemeral mean? Concrete means the real situation, the actual situation of the person, rather than the being bound by abstract categorizations as matters of law. The third point is that we do accept that clearly there comes a point where a consequence of the regime is no longer a consequence of the regime if either the individual or a member of his family takes a wholly unreasonable or eccentric approach. And that's our proposition. The judge, we submit, takes account of all the natural and foreseeable consequences of the measure, but not of the situation brought about, I would respectfully put in, about by wholly unreasonable or eccentric reactions or choices in response to that measure. And there is an example of that in the first instance cases, the case of AU, where the mother said, I disagree in principle with this whole control order thing. It's an insult to my dignity, that kind of thing. And therefore, I'm not even going to submit to the process of getting approval. Now, one can say there that there's, as it were, a novus act, or a new intervening act. There's something has come in there, which is a wholly unreasonable response. And therefore, it isn't the consequence of the regime. It's the consequence of an eccentric or obstinate or a decision that the court can say we're not going to respect.
Well, supposing the mother just had said, well, you know, I've got a lot of things to do, and frankly, I'm not going to go up to the place concerned.
Well,
I mean, not
yes.
it's not, you know, she's not making any great thing about, you know, she just says, well, you know, I've got other things to do. I mean, she could have gone, she could have given priority to this rather than something else. She says, well, I choose to go and do something else.
My Lord, what we respectfully submit is that if it's the natural or foreseeable consequence, I'm sorry, I'm going to try and answer the points straight, but if it's a natural or foreseeable consequence of things having become much more difficult, the 150-mile trip, the expense and all that, which is really what the judge seemed to regard it as here. He didn't criticise the mother for saying, I can only go up once, I could only go up if I was accompanied by then you take that into account. That's to say that is one of the consequences. Where, as in the AU case, it's wholly unreasonable, it's discounted. In your Lordship's example, I would respectfully submit that you do say one of the consequences of it being made much more difficult is that the mother has said, I can't be expected to go through with it, and that would be taken into account.
Well, not that I can't be expected to, but I just choose not to.
Yes.
I mean,
yes.
In that situation, does that make something which would otherwise not be, you know?
Well, my Lord, I think I would accept that there has to be a value judgment there as to whether, in fact, it is the natural consequence, or one can. I mean, the principle is this? Would one say this is really a result of her own choice? Look, I can't be bothered in that case. In which case, it's on the wrong side of the line. Or is it something which, given the difficulties, the costs, and all that, one says, well, that's a natural and foreseeable consequence. I'm not going to criticise someone for taking that approach, which seems to have been Mr. Justice Keefe's approach. It's not insuperable, but there were problems. In fact, we don't accept that Mr. Justice Keefe was operating on the basis that he couldn't be visited at all. He was saying he can be visited, but it's all become much more difficult, and inevitably access will be restricted. But, my Lord, so it's really the legal principle has to be, at what stage does one say this ceases to be the natural and foreseeable consequence of the regime as a matter of causation, and has become the result of a conscious choice. I'm not going to bother. But we do say that that's where there's something unreasonable about that. I mean, I think I would be prepared to categorise if a mother says, and the son says, I desperately need my mother's visits, and the mother says, he needs my visits. And then she says, though they're readily attainable, I'm not going to bother. And one would say that that's an unreasonable choice. But that, in our respectful submission, is but that wasn't what was decided in this case. And what my learned friends are saying is, you construct some. It's kind of rather like the provocation situation. You construct some notional individual who isn't Mr. AP, and some notional family which is not Mr. AP's family, and you say, what would they do faced with a 150-mile trip with the costs? And you attribute some of the circumstances to them and not others. We say that is far too sophisticated. What one says is, broadly speaking, is this a natural and ordinary consequence of the regime. And one thing you can say here quite clearly, and Mr. Justice Keith clearly did say it, is one of the natural and ordinary consequences of this regime is that access in terms of visits by the family will be severely handicapped and become much more difficult.
In practical terms, looking at it from the point of view of the Secretary of State, who has to decide whether or not to make an order and the terms of it, and in our case, the modification of it, does the Secretary of State have to carry out some sort of an investigation as to what the impact is going to be of modifying the order so that the controllee is going to have to be 150 miles away from his home? I mean, one can see considerable practical difficulties facing the Secretary of State if what you're saying is correct.
Well, my Lord, firstly, as a matter of fact, as your Lordships know, there are very few of these cases. I mean, I think there are a dozen. So requiring some degree, before this exceptional power is exercised, some degree of careful deliberation is not unreasonable. Indeed, one can see that in this case there was, before the relocation, considerable degree of, they were inquiring into whether there were mosques in the area, what the ethnic composition was. They do have to, in our respectful submission, before bringing in an order of this sort, carefully investigate what the consequences were, and they do, in fact. So it's not, there are very few of them. They are very extreme inroads into the ordinary civil liberties of people living in this country. So it's not unreasonable to say, no, you must have full consideration of the likely consequences. But, my Lords, one thing we say would be clear in a case like this is that moving someone whose family are of modest means on benefits 150 miles inevitably is going to make it far more difficult for them to keep up the kind of contact that they had when they were just around, well, in the same city.
It's a consequence of your argument, is it not, that you could impose precisely the same restrictions on two persons, A and B, and in the case of A, you would be depriving him of his liberty, but in the case of B, you would not.
What, because of the person who's got helicopters at his disposal?
No.
I mean,
One is an atheist, and the other is a Muslim who needs a mosque.
Oh yes, well, yes, it is, and indeed that's looking at.
Yes.
You have to look at all. You have to look at the person. Yes, my Lord, I accept that. Yes, it does depend on all the circumstances. Yes.
Well, one of them might actually live in Stoke-on-Trent.
Yes.
Which is where this chap was saying.
I think, my Lord, we're not supposed to.
Why not? It's in the paper.
People do.
I see. Okay, fine. I'm so sorry. No, I'm so sorry. I forget. I thought. It's they might. My Lord.
I mean, he might have to be sent to Hackney in order to get away from his associates.
Yes, I accept that. But my Lord, the significance of is one looks at the concrete situation. You see, well, has he been moved a long way from home, as it were? And if he has, then you have to have regard to that.
But I mean, following up from Lord Phillips' question, I mean, likewise, if, for example, it suddenly becomes impossible for the family to visit because of somebody breaks a leg or something, I mean, the same situation.
Cheap fares are removed.
What? Cheap
Fares are removed.
Yes. Well, my Lord, look, of course I accept, my Lord, that there are, if somebody breaks a leg, there's going to be, but it's not a natural, an ordinary consequence of the order at that stage.
No, but if suddenly somebody becomes able or unable to visit on a long-term basis because of a change in health or whatever it may be,
yes,
the same situation could become a deprivation of liberty that was not before?
My Lord, I accept that is one of the consequences, that there could be circumstances, in our respectful submission, they'd have to be quite extreme. There could be circumstances where and that's why you'd then seek a variation. This has become a deprivation of liberty. There are circumstances. But
But you would say that is inescapable. Once you get away from the notion that deprivation of liberty is the sort of absolute concept that
Yes.
Lord Hoffman and Lord Carswell thought it to be.
My Lord, yes. My Lord, yes.
The case seems to show that one of the factors to take into account is whether there is what is sometimes described as social isolation.
Yes.
I mean, take AU, for
Yes.
example.
Yes.
Now, AU was saved from social isolation, according to Mr. Justice Mitting, by the regular visits of his wife and children.
Yes.
Now, if he hadn't had a wife and children, the position would be completely different. So if you're comparing him with somebody who didn't have a wife and children, it would simply be different. But that's the consequence of the Strasbourg's approach to looking at the concrete situation of the particular person.
My Lord, I respectfully agree. And indeed, that really flows from what my Lord Phillips said in the Court of Appeal in the JJ series of cases, that you take the person, as it were, as you find. Perhaps because I think it is.
This is the Hermit, is it?
Yes, the Hermit. Yes, it's at tab 9. Perhaps I should take your lordship's to it. It's not dealt with in such detail, but the basic approach is approved in the House of Lords. But this, yes, paragraph 14 in JJ. Yes, Mr. So paragraph, so page 458 in tab 9.
Now, this is one of the rare decisions of the Court of Appeal in this area, which was actually upheld by the House of Lords, I think.
Well, he was upheld also. But
Where are we looking?
it's page 458, paragraph 14. So 458D, my lord. Mr. Sales criticised the judge's concept of interference with normal life on the grounds that this was at odds with giving liberty an autonomous meaning. The effect of his objection was that on the judge's approach, whether measures amounted to a deprivation of liberty might depend upon whether they were aimed at a hermit or a long-distance runner. We do not consider the judge was suggesting this. The judge was considering the extent to which restrictions would prevent an individual from pursuing the life of his choice, whatever that choice might be. These criticisms of the judgment overlap with Mr. Sales's fifth criticism, that the judge concentrated excessively on idiosyncratic features of individual cases. For instance, he had regard to the fact that the respondents lived alone, without social contacts, in flats which were not of their own choosing. We do not consider that this criticism is valid. The Strasbourg Court does not turn its back on the impact of restrictions on the individual. In considering the significance of confinement, it can be very relevant whether the individual is confined in his own home or confined in quarters where he would not wish to live. In this case, this did not prove a critical factor, and the judge correctly observed that the fact that all except GG had to live in new accommodation was of less significance than if they had had to move out of long-established homes. And then the agreed fact showed that the respondents had little social contact, for there were few requests for approval. This, however, could as well have reflected the consequences of the obligation. Mr. Starmer observed the requirements to obtain personal particulars, a photograph from any visitor involving, no doubt, an explanation of why they were needed was a serious inhibition on social life. But it's really the proposition that the Strasbourg Court does not turn its back on the impact of restrictions on the individual and the concrete situation which was upheld by the House of Lords in JJ, that it's a specific approach. Yes.
I mean, Mr. Sales was back then arguing for the position that he eventually persuaded Lord Hoffman and Lord Carswell was right, but
yes.
not the rest of the court.
Yes. Yes, I mean, just to take your lordships to Lord Bingham at paragraph 18 in tab 5, just one sees the same point supported by I think I can just take you to the first sentence, paragraph 18, 652 E to F. In assessing the impact of the measures in question on a person, the situation of the person subject to the court has assessed the effect of the measures on the life the person would have been living otherwise. So you look at the individual, and then it deals with the cases of Raimondo and Ciancimino. Those are the mafia cases, of course. And then again, paragraph 21 at page 654C, one has Lord Bingham approving the judge's approach. He noted the control persons were all single men except the requirement to supply the name and date of birth and photographic to obtain prior of anyone wishing to visit, deterred all but the most courageous of visitors. So it looks at the individual's situation, and the judge's approach in looking at that was held to be entirely reasonable. Obviously one has the rejection too of the argument that an overlapping with Article 8 is impermissible, and that factors that are catered for by Article 8 can't be taken into account.
So what was that last part? Where was that in?
Yes, Lord Bingham also took the approach that the fact that there was an overlap between Article 8 and Article 5 was not a reason for saying that a factor catered for by Article 8 should not be taken into account. That's at paragraph 23. He rejects the criticism of the Secretary of State at 23E that he had wrongly had regard to restrictions on human rights protected by other specific articles. Yeah. That is rejected by Lord Bingham and indeed by Baroness Hell and another Lord Brown.
So in a case like this, you, as I understand it, you say, I haven't had the pleasure or otherwise of sitting in one of these cases before, so I'm not familiar with it. But you say the fact that it's not going to be a breach of Article 8, you set that aside, is that right?
Yes.
You set that aside, and you nonetheless take it in, you may take it into account in connection with deciding whether it's been a deprivation of liberty. That's, as I'm saying.
Yes. So indeed, if one goes back to Guzzardi, the particular restrictions in Guzzardi were held to be Article 8 compatible, but nonetheless you put them all together and you had a deprivation of liberty.
Well, if they don't constitute an interference under Article 8, then it's hard to see that they're going to be of any relevance. Yeah. But you're considering a situation where they do constitute an interference under Article 8, but you can justify that on the basis that, it's proportionate to the particular situation.
Whereas necessity and proportionality are really irrelevant considerations, aren't they, when you're considering whether the effect of the order is to deprive a person of his liberty.
My Lord, yes.
They can be as proportionate and as necessary as you like.
Yes, but
that's not the point you're on.
Yes, because Article 5 being absolute doesn't contain within it that permission to make that value judgment that, well, this is nonetheless necessary.
I mean, the point you're making is essentially that made by Lord Phillips in the Court of Appeal in JJ at paragraph 17 to 19, I think.
I'm very glad. It's volume 2 at tab 9. Yes, page 458, yes. And your Lordship was referring me
to... Well, I was referring to what's said about Mr Sale's third criticism and the relationship between Article 5 and Articles 8 and 9.
Yes, we turn to his third criticism, page 459 at B. He said that the judge should not have had regard to restrictions which engaged other articles of the Convention, such as Articles 8 and 9. Those made provision for qualified rights, interference with which could be justified. It was wrong, he suggested, for Mr Justice Sullivan to have regard to the availability of one's home, the ability to admit or refuse visitors, etc., etc. These were all matters referred to by the judge, but they were not the principal factors that led to him to conclude that the orders produced deprivation of liberty. We do not agree that he should have disregarded these matters, merely because they could have been made the subject of complaint under other articles of the Convention. The different Convention rights overlap, and it would be contrary to the approach of the Strasbourg Court to consider them in watertight compartments. We need only point by way of example to the particular importance that the Commission attached in Guzzardi to the possibilities of social contact, see paragraph 94. The European Court of Human Rights also had regard to the opportunities for social contact. These matters do not of themselves constitute deprivation of liberty. Where, however, they are features of a regime at the heart of which is physical confinement, they are relevant in considering whether restrictions cross the boundary between restriction on the freedom of movement and deprivation of liberty. Yes, and I'm very grateful to my Lord for
This is an application of the principle at the top of the page, which is a quotation from Guzzardi,
Yes.
that you have regard to the type, duration, effects,
Yes.
and manner of implementation of the measure in question. That's to say, the particular measure in question.
Yes, my Lord, yes.
But I mean, just so as I understand, the court could come to the conclusion that, do I understand that it was a proportionate interference with the right to respect for family life
Yes.
because of the importance of the aim being sought. So that here, the fact that, if you just looked at in isolation, the fact that he could not have as regular contact with his family, well, that was just something which, yes, it was an interference, of course, therefore the article is engaged, if you like to say that, but nonetheless, paragraph 2 trumps that.
Yes.
Nonetheless, you say, even though that is all right in isolation,
Yes.
when you add it into, you nonetheless add that in,
Yes.
and it can nonetheless be a very
decisive.
significant factor,
Yes.
as I understand it.
Yes, my Lord, yes, absolutely. That is a submission. And then, of course, you've got to start with the core deprivation of liberty by the curfew, and you've got to have that's got to be of sufficient significance for us to be in
the
Article
territory,
5 territory. But then what can push it over, in the case of 16 hours, is accompanied by severe restrictions. And your Lordships will have seen from the analysis of the other post-JJ first instance decisions that there's descriptions of 16 hours where you are in your flat and you can be visited as on the borderline. And indeed, Mr. Justice Mitting agreed with the conclusion reached by Mr. Justice Keith in this case, saying that that the social isolation in this case made all the difference. Whereas in another 16-hour case, I think it's the AU case, it wasn't sufficient.
But he was living with his family.
Yes, he was living with his family. And it can make the difference. My Lords, I've now summarised, I think, the position by reference to the Roman 5 and the Court of Appeal's majority did not itself expressly decide the appeal on the basis that Mr. Justice Keith had given undue weight to a subjective fact. That's at page 3 of the speaking note. In fact, that argument is developed in my learned friend's part 9. It's developed for the first time, but just seeing how it's put there, it's in the core volume, and it's in the case of the Secretary of State. And so that, as it were, one can see what the argument is, because it's not set out in any judgment. 9.1, page 25, the appellant submits that person-specific factors can be decisive to a conclusion that restrictions on freedom of movement amount to a deprivation of liberty. In support of that submission, he relies on a number of authorities in domestic courts. Then, if I can just take you very briefly to the citation from Guzzardi at 9.5. In particular, the European Court's choice at paragraph 92 of Guzzardi of the phrase "his concrete situation" to describe the starting point for determining whether there's been a deprivation of liberty is instructive. The European Court of Human Rights was clearly intending to refer to those aspects of the measures imposed upon him, his situation, which were not ephemeral or volatile. Concrete, as I put to your Lordships, as a different meaning of concrete, which is actual as opposed to theoretical, existential as opposed to dictated by the abstract category to which the situation belongs. And that the reason for the use of the word concrete and actual was to indicate that the court was looking at substance rather than categorisation in domestic law. So it wasn't enough for the Italian government to say it's not regarded as imprisonment here, and he's not locked up in a cell. You have to look at the actual situation, the concrete situation of the particular individual, and decide whether in all the circumstances it is more than a restriction of movement and has become a deprivation of liberty. And then there is a criticism of the different ways in which the majority of the House of Lords dealt with the question of looking at the situation of a person in the situation. At 9.10, the majority of the House of Lords in JJ summarised the task of the court as being to assess the impact of the measure on a person in the situation of the person subject to them. They thus focused on an objective test, what the effect would be on a person in the situation, not was the effect on that particular person. We respectfully disagree. It is about the particular person. That is the focus of the majority in the House of Lords. And then at 911B, they say, if and insofar as Lord Bingham or Baroness Hale did place reliance on subjective factors, their approach should not be followed, because the Supreme Court should prefer the recent guidance of the European Court in Stukaterov. We say that that case has got absolutely nothing to do with it. It's completely irrelevant. Stukarov is a case where it was accepted, the person was practically tied down to his bed in a cell, so there was no dispute about whether he was deprived of liberty. The only question was whether there was consent. And all the remarks about subjective were in the question of whether the consent. So we say that the idea that that's introduced some new test is, with great respect to my learned friends, hopeless. And then at page 28, it reinterprets Lord Hope in Austin, where he said you must look at the specific situation of the individual. And at the top of page 28, 912, thus Lord Hope's reference to the specific situation of the individual should be understood to require, in a case where there was no issue of consent, a detailed analysis of the specific situation in which the individual was placed and how anyone in that situation would be affected, rather than a detailed analysis of the specific individual and how he might be affected by the situation. But we respectfully speak, you look at the actual individual, his circumstances, which include his family circumstances, and the effect on that. It is right, and my own friend, we would accept this, that if there is something exotic or unreasonable in the choices that are then taken in response to the regime, those matters may be matters that you discount. But with that proviso, we submit you do look at the actual situation of the actual individual rather than some notional individual. And then at 9.17, my learned friend identifies the error and says, Mr. Justice Keith therefore erred in finding that the modified control order imposed on the appellant deprived him of his liberty because of subjective factors, i.e. the fact that the appellant would be less likely to receive visits from his family because even though he was to be moved to a town only 1 3/4 away by train, his family would, as a result of their individual frailties and choices about where and how to live, find it difficult to make the necessary journey. Well, they lived in London. This place is 1 3/4 hours away. It's 150 miles away. As a matter of natural and ordinary consequence, this will make it more difficult for them to maintain contact. And to say that it's about individual frailties and choices is, in our respectful submission, to underestimate the fact that there are objective reasons why, the objective and comprehensible reasons why the contact was less.
Just a pure fact, I'm sure it's is there any restriction on the amount of telephoning that can take place between?
No, my lord, no, and indeed, I'll show your lordships, if necessary, initially he said that he only had contact with them by phone, so he could phone them. Yes, my lord, that's the position. I think I can give you that reference. It's at page 181 of the appendix. Is it page 180? There's an analysis of his situation. It starts, the analysis of the situation, page 179, the impact of the relocation.
The order makes it clear, doesn't it? And which is set out in paragraph 2 of the facts list, statement of facts list.
I'm right. There is telephone contact with his family, yes. So, my lords,
Does one take that into account?
oh yes, my lord, it's relevant that there is telephonic contact, yes. So, my lords, I'm at Roman 5 of the summary. We say that in any event, the fact of relocation to a distant and unfamiliar place with inevitable problems for the maintenance of family contact was an objective fact, and it was a natural and predictable effect of relocation that contact with his family would be greatly restricted. So it's not, basically we say it doesn't belong to that category of responses such as the mother in AU, where you say, well, I'm going to discount that, nor did the judge discount it. And then as to the alleged inconsistency between Mr Justice Keith's findings that the difficulties in his family visiting were considerable but not insuperable, and his reference apparently to the fact that he could still visit and see and be visited by his mother, his brother and his sister's 3 children, we say there's in reality no inconsistency. Your Lordships have seen his remarks at paragraph 97. They have to be read in light of his findings at paragraph 88. I can just take your Lordships briefly to those. In the appendix at page 55, one has at the bottom paragraph 87, this justification has to be balanced against the incontestable hardship for AP in being isolated from his mother and his brother. His evidence was, and he did give evidence in accordance with his statement, that while he was in Tottenham, they would visit him about twice a week, and that every week he would see his sister's 3 children, who he would take to the park. His move has had a profound impact on how often he sees them. His mother has not visited him at all, and his brother has visited him just the twice. This is just as upsetting for his mother as it is for him, because at present she needs AP around more than ever. That is compounded by the fact that he does not know anyone in the town where he now lives, and sometimes speaks to no one in the course of the day, other than short calls, that's to his solicitors or to his mother and his brother. It is true that the town where he now lives is not that far from London. The journey by rail takes about 1 3/4 hours, and trains travel every half hour. It's 150 miles. It is also true that there is no limit on the length of time AP's mother and brother can spend with him if they choose to visit him, and there is, of course, no need for them to seek prior Home Office approval. But the practical difficulties of visiting him are not inconsiderable, bearing in mind that his mother now looks after his sister's 3 young children. She cannot go to the town where AP now lives on those days when she has to take the children to or collect them from school, and if she was to go to that town, she would have to take the children with her. It is said that she cannot go to that town without AP's brother because she has never left London alone. The only day of the week he could go when the children are not at school would be on Sunday. But these practical difficulties are not insuperable. The fact is they could visit AP en famille on Sundays, as well as on the other days of the week outside the school terms, and they could travel at off-peak times to get the advantage of lower fares. Having said that, there is unquestionably another significant hardship for AP in having to live in the town where he now lives. It is difficult for him to feel part of the local community. He claims that the local Muslim population comes mostly from...
Well, this is moving on to 7.
Yes, that's so. But then if one looks at that, so paragraph 88, I'm obliged, if one looks at that and then one looks at paragraph 97, we say, taking a fair approach to this judge's careful judgment, the ratio is the first sentence of paragraph 97, which is where he rightly describes it as the equivalent of internal exile, removed from his normal haunts and acquaintances and from ready access to his family. So that's the first sentence, which is unobjectionable and, in our respectful submission, correct. He then goes on, it's a matter of pure opinion, which does not permit detailed elaboration. And then he makes this further remark, but had he remained in London so that he could still see and be visited by his mother, his brother and his sister's 3 children, my view would have been different. He clearly is meaning so that he could still see them regularly or easily or without particular problems, because he's already made the point that, of course, it's not, the problems are not insuperable. He could see them, but it's much more difficult. So he's taking, firstly, the physical fact of the distance and the difficulties it creates, and taking into account the fact that this...
Mr Fitzgerald, the reference to now the mother having to look after the three sisters. I mean, we know the three nieces. We know why from the confidential annex. I mean, in what circumstances is that now before us? Pages 60 and 61.
Well, I think it's dealt with at paragraph. I think it's dealt with at paragraph in the open that the consequences of. Yes, 181. So I think we have it in any event.
Sorry, 181 of what?
181 of the same appendix. Yes.
I'm sorry, we're not.
Yes, so paragraph 18 of page 181. I think it refers to the convictions.
No, I know, but I'm sorry. My question is, why have we got the confidential annex?
I think it's referred to in paragraph 90 of the
90 of what?
90 of the judgment.
Because it's part of the factual matrix of the.
Well, it's one of the factors that the judgment mentions at paragraph 90.
Yes.
It's not quite clear what he makes of it, but he says there are three other factors I should mention. The first is contained in the annex.
Does he say what it is? No.
No.
I mean, what is it that puts this confidential annex into the public arena?
It's not in the public arena.
This case is presumably. I understand it's explained by my learned friend in a footnote to his case. Can you just give me the reference? So it's in the respondent's case, page 6, footnote 4. A number of measures have been taken by the courts below to secure the full effectiveness of the order for the appellant's anonymity. I see,
isn't it? Oh. Well, have I not read that name elsewhere?
I couldn't myself understand what was confidential about the annex numbers.
it's the name of the town, I think. It's the name of the town. We had conducted the hearing. I know in many of the other cases that the towns have been identified.
No, but apart from the town, is this page 60 and 61?
Yes.
Well, insofar as this is only put in an annex in order to protect the anonymity, it's in the record. Isn't this record a public document?
No.
Isn't this record a public document? The core volume.
My lord, I'm not sure that just by being included in the record it becomes generally available.
Why are the details of the? I mean, are there any of the details? None of the details of the conviction of the people mentioned in paragraph 8 can be confidential, can?
Yes. It helps to identify him because it identifies the members of the family.
Well, that's matter. But I mean, do I take it that the fact that it begins at 6 means that there was something which has been closed? No.
Well, I think my learned friend may be better able to.
That might help because I think I may be the only person here who was actually in the original hearing before Mr. Justice Keith. The paragraph numbers on pages 60 and 61 are the paragraph numbers in the fully open judgment to which these details relate. For example, if you look at paragraph 14 on page 32, you will see that some details are given there, and the last sentence says the full text of this paragraph is contained in the confidential annex. And then if you go on to page 61, you see the fuller version there with number 14. So there is a cross-referencing back to paragraphs in the main judgment. The facts that are in the confidential annex were discussed in open court during the hearing before Mr. Justice Keith. but the anonymity order meant that they could not be reported. In order to try and make that fully effective, the device of a confidential annex was used to try and protect these details, because if these details are made public, then AP's identity will be very rapidly known because of the names and places that are mentioned in the confidential annex.
I haven't myself come across this technique before. Was it an invention in this case, or is it?
I don't think it's an invention in this case. I have seen it elsewhere, and it was suggested and assented to on all sides without any.
Why should he be anonymous?
That's a good question.
Well, the statute, sorry, to go right back to the statute makes provision for anonymity orders to be made, and it is routine in control order cases that they are made. I know that this has been the subject of discussion probably here since Mr. Justice Keith's judgment, but the practice has always been that anonymity orders are made except in exceptional cases. The anonymity order then prevents the reporting of details that might identify the individual, and the confidential annex was used as a device to try and make that fully effective, and that explains the history of how this comes to be.
Well, that practice is now open to question, isn't it?
Lord, I understand that is, but that is the historical reason why.
I mean, as it happens, this particular appellant is no longer under a control order because it's all changed.
Well, that is right, and he is now subject to deportation proceedings, but under an anonymity order in relation to those.
He's an unsuccessful asylum applicant as well, is he? Or has he never?
Well, that goes back an awful long time. I mean, he originally made an application in 1992, but he got indefinite leave to remain in 1999. It was never dealt with.
Lord, I think that the question of whether there's an outstanding asylum application is a wrinkle that has not been fully resolved. But the deportation appeal, which was heard a couple of weeks ago, didn't deal with that either.
Was he raising human rights objections to deportation?
Yes, he was.
He was. Well, that might well justify
What were they?
anonymity.
Primarily, they were Articles 3, 5 and 6 of the Convention relating to his treatment after he returns.
But I mean, this is another case like, I forget the names of them all, but this is where there was a memorandum of understanding with the government of the country to which it is intended to deport him.
Lord, yes.
And is that, what were those cases about? What?
The Offman case.
Yes, that's right. Offman, who we did name. And is this memorandum of understanding, I mean, are all those points all raised again, are they?
Yes, without retreading ground that's already definitively decided, but that is the field in which the deportation proceedings took place. So the position, Lords, is that we would, I think on both sides, have been expecting the anonymity to be preserved, at least in the first instance, unless that is to be reviewed by this court.
Why exactly would you expect that?
Lord, because he has been anonymous so far, and if that anonymity is to be set aside, we respectfully say that it should at least be the subject of some submissions and consideration.
Well, one knows that the Secretary of State quite often favours anonymity in cases where an individual is raising concerns as to his safety if returned, on the basis that if anonymity is lifted, this may give strength to his arguments as to what may happen to him.
Lord, yes, that's certainly one of the reasons why anonymity in routine asylum cases is sought and granted.
But that's very far from this case, where actually there's no question of the whole. They're trying to send him back to a country who know perfectly well who they're getting, because they've had to give a memorandum of understanding as to how they're going to treat him.
Lord, yes, that's why I don't rely on that in the deportation proceedings in relation to this individual, but equally, so far as the control order proceedings are concerned, and even insofar as this individual is concerned, there remain reasons why anonymity could be asked for, and in the deportation proceedings, it was not something to which the Secretary of State objected.
Yeah, the question always is whether the press might have an interest and so on.
Indeed.
You know, there's often a sort of conspiracy between both sides. Both would say anonymity, but the people who might have an interest in not having anonymity aren't actually. And of course, they haven't asked to come in this case. So.
Lord, no. And in the deportation proceedings, there was press interest, but there was no application from the press for the anonymity to be lifted.
But at any rate, none of this was closed material.
Lord, no.
Well, my Lord, obviously, we would request that the status quo be maintained until such time as we can put forward arguments on this issue. We didn't. The truth is, we didn't see this coming, and I apologise for that. That we hadn't, as it were, thought it through. But in the meantime, perhaps we could consider. There has been anonymity so far, and there has been no mention of the town so far. What can be done? But it's only been mentioned once, I think. But my lords, and it may be that your lordships will take a view as to whether it's appropriate. But I wonder if, in the meantime, whilst we formulate, the obvious problem is that the question of harassment in the same place where he is now on bail, and there may be Article 8 and Article 3 submissions that could be made to continue to justify anonymity in the light of the fact that he's in the danger. But I appreciate that the things have changed since, I think it was the first case your lordships heard.
Well, it was my Lord Rotter's judgment in, what's the case called?
No, it was
Well, it was all of it.
Yes. Well, my Lord, I appreciate, but could we, as it were, consider our position? Because clearly there could be risks to him.
Clearly, you would have to make submissions on it before we ever considered such.
My Lord, yes. I'm afraid.
But so far as the issues in this appeal concern, this material is only of limited relevance, isn't it?
Yeah.
Paragraphs 17, 87 and 90 appear to be the relevant paragraphs.
Yes.
It's difficult to explain.
Of course.
Yes. Yes.
Yes, well, then it's probably appropriate to direct that this annex should remain confidential pro tem, so far as general publication is concerned, and nothing should be published that would identify the identity of AP until further order. But I did note that one representative of the media was here and is here no longer, so you will not have heard that.
Okay. Well, my Lord, we will obviously have to take...
to witness Joshua Rosenberg.
Oh, right. Okay. Thank you. We'll obviously do what we can in those circumstances. My Lord, the point I was on, which is that the Roman 6, is there is no real inconsistency unless one takes an unduly analytic approach to that one word could. That it's plain in our respect for submission that what he meant was could regularly, could frequently.
Yes, I think we have that.
I'm so sorry, my Lord. For Romans 7, we rely obviously on the judgment of Lord Justice Carnwath, which in his dissenting judgment.
Where are you reading from now?
Romans 7, my Lord, page 4 of the speaking note. The case called for a value judgment within the grey area occupied by curfews between 14 and 18 hours and the factors of internal exile and social isolation.
Does this wonderful phrase internal exile mean anything? Does it add anything apart from being vivid? Has it got any legal significance, Mr. Fitzgerald?
No, it has no. He says he'd characterise it. One thinks of the Decembrists being sent off to Irkutsk but equally the Italians, the mafia cases. They do. I think it is referred to. So you go from, as it were, Sicily to Piedmont.
Yes, absolutely.
It's internal exile. But internal exile, we respectfully submit, is an appropriate way of describing someone being relocated to an area a considerable distance from his normal.
But in itself, that doesn't breach Article 5, does it?
No, absolutely, my lord. No. For example, Ciancimino, one of the cases. The internal exile was from Sicily to some place in the north, Rotterdam, I think it was called, and that was held because the curfew was only 12 hours. I think it was actually only 11 hours to be consistent, because in addition, the life that the person was leading outside that curfew was the normal life of a person. So, my lord, internal exile has been approved in the series of mafia cases, the Ciancimino-Raimondo cases, as not amounting to deprivation of liberty, because the choice of curfews in those cases were between 10 and 12 hours. Therefore they were held not to be deprivations of liberty and not to be inconsistent with Article 8. However, just to make the point while we're on it, in those cases, the degree of association with the townspeople of the northern town was far greater. The regime was much less restrictive, and the curfews weren't comparable in any way. They tended to really just be overnight curfews. And so
you say here you count it in as one of the factors, given that you're in the grey area.
Yes, my lord, yes. So at Roman 7, we just adopt the reasoning of Lord Justice Carnwath, who held that it was, in the end, a value judgment within the grey area occupied, and that the factors of internal exile and social isolation were relevant and could tip the balance. And we say Lord Justice Carnwath was correct. Just whilst we're on that, what Lord Justice Carnwath also said was that it's important to have regard to the decisions of the first instance judges, and your lordships now have the short summary of the three first instance decisions of most relevance: the AH case, the AU case, and the GG case. And your lordships will see that in AH, the 14-hour curfew with no visitor restrictions was held by Mr. Justice Mitting to just avoid being a deprivation of liberty. And one sees at page 2 the citation from paragraph 23b, H was required to live in a flat in a city which was wholly unfamiliar to him, subjected to a high degree of social isolation. This is a significant feature which points to deprivation of liberty rather than restrictions on liberty. And then the fact that his wife did not live with him, indeed, the fact she did not live with him was relevant because it was a feature of his social isolation, and it was held just to avoid being deprivation of liberty. AU, just if one sees the bold italicized heading, it was a 16-hour curfew when living with his family. It was not a deprivation of liberty. A 16-hour curfew when he was not living with his family, but they enjoyed considerable access to him, was as close as possible to the point of being a deprivation of liberty, but did not quite cross it. And one sees the attitude of the mother summarised on page 4 at C, and then paragraph D, citing from paragraph 19, he would have reached the same conclusion as Mr. Justice Keefe on the facts of AP. He was satisfied that AU was not deprived of his liberty because he was able to live with his family in accommodation which was adequate for them all. The continuing social isolation of the family resulted not from the obligations imposed by the control order, but by the unwillingness of friends or associates to seek Home Office approval. The issue was more finely balanced when he was in the flat in Hackney, because conditions did not permit his wife, that was a basement flat in Hackney before, to live with him permanently. However, they enjoyed considerable access to him and thereby greatly mitigated the social isolation. At that time, the circumstances came as close as possible to the point at which he must be adjudged to be deprived of his liberty, but did not quite cross it. and then GG, the decision of Mr. Justice Collins that a 16-hour curfew, and there we can name the places, and relocation from Derby to Chesterfield, where no difficulties were identified regarding family visits, and there were no visitor restrictions. And that's, I think, only 30 miles from the two places. And one can see again, if one goes to page 6 to our paragraph C, that at paragraph 53, Mr. Justice Collins said that the restrictions put the case very much on the borderline, but were not a breach of Article 5. A 16-hour curfew coupled with other restrictions could amount to a deprivation of liberty. The key lies in the extent of social isolation, which may be determinative in favour of deprivation, where there has been a removal from the home area, coupled with a restriction on visitors. The two had not occurred in G. So one does see a consistent body of recognising that 16 hours can be a deprivation of liberty, that it all depends on the degree of social isolation and the degree of removal from one's normal setting, and that the position then in these cases is that the judges of first instance are consistent in their approach, and that two judges of first instance have said that the approach of Mr. Justice Keith was effectively correct in this case. And we do submit that no errors of law have been identified. And my Lord, the rest of the speaking note simply elaborates the points that I've put to your Lordships. Can I just take you very swiftly then?
Well, I think, Mr. Fitzgerald, you might allow the speaking note to speak for itself.
Well, if your Lordship is suggesting that I call it a day, can I be short in opening and long in reply if necessary?
Yes.
I think that would be acceptable.
Okay, well, my Lord, it is all set out then in the rest of the...
Several times,
my Lord, yes. Well, in that case, I'll say no more at this stage.
Yes, thank you. Miss Marcus, is there anything you wish to add? Yes, Mr. Thomas.
Please, your Lordships. Lords, the central thesis of our case is one that has been present throughout the appeal proceedings to the Court of Appeal. As my learned friend pointed out, it was the third ground of appeal to the Court of Appeal. If your Lordships go to the core volume of the appendix, where the Court of Appeal's judgment is on page 12, the third ground of appeal, which we respectfully say was not a portmanteau ground of appeal, but neatly identified the precise issue in the case then and in the appeal before your Lordships now, which is that Mr. Justice Keith erred in law in relying on the inability of Akey's mother, sibling, and nieces and nephews to visit him as a decisive factor in rendering the control order obligations a deprivation of liberty, as I said, because the question whether there's a deprivation of liberty does not depend on subjective, and we put that in quotes deliberately, subjective or person-specific impact of the measures on the controlled person. And we identified it exactly like that, because what we were trying to do was to encapsulate the difference between those factors that come with a particular set of control order obligations that will be felt by any person who is in that situation and subject to that package of obligations, and those effects which are produced because of perhaps one might call idiosyncratic choices or features of the individuals involved. It won't necessarily just be the controlled person, because members of his family, as this particular case demonstrates, may also have their own idiosyncratic choices and frailties that lead to a certain set of effects on the individual person. And we respectfully say that if one is taking an objective approach which is what the Strasbourg jurisprudence and your Lordship's previous decided cases show. If one takes an objective approach, it cannot be right to take into account those idiosyncratic matters because they lead to some rather odd effects, which we have pointed out in our printed case and we will come back to. And fundamentally, we respectfully say that the error which Mr. Justice Keith fell into was that he took into account decisively matters which were essentially the choices of AP's family not to take up the opportunity which they had to visit him in his new location. Admittedly, it was further away, it would have been a bit more difficult. But what Mr. Justice Keith relied on was the fact that they, for almost all intents and purposes, hadn't been. They had stopped visiting him. But we respectfully say that when one looks at it, that was a matter of choice, and that choice and the reasons for those choices were idiosyncratic choices and frailties. In order to set out the background to that, may I draw...
What makes a choice idiosyncratic?
Lord, simply if it's your own, perhaps whim is the wrong word, but if it's entirely optional whether you take up a particular opportunity or not, then that is an idiosyncratic or individual choice that one has made.
Any choice. If you have a choice, you have a choice.
If you have a choice, you have a choice. If you don't take up the choice, well, that has an impact on the controlled person. That's not an impact which you take into account when deciding whether or not there has been a deprivation of liberty. You must look at that question objectively. The opportunity is there. There's no insuperable difficulty. It's perfectly feasible for the visits to take place. And so the fact that the members of the family choose not to take up that opportunity is not something which converts that package of obligations into a package which deprives the controlled person of his liberty.
Mr. Chairman, sorry, just so I can be absolutely clear, I mean, going to page 55 of the annex, paragraph 87 of Mr. Justice Keith's judgment, I mean, there it is set out that in fact his mother hasn't visited him at all and the brother's only visited him twice. You're saying, by all means, take account of the fact that it's much more difficult for them, but ignore the fact that they have actually chosen not to go. Is that it?
Lord, yes. We wouldn't necessarily agree with much more difficult, but yes. Well, the fact that somebody is further away inevitably will make the journey to visit more difficult for anybody. Anybody's going to have that. But the fact that they have actually chosen not to do it when they could, that is not something which should be taken into account.
So you say ignore the fact that they've chosen not to overcome this not inconsiderable practical difficulty. Ignore the fact they've chosen not to overcome this not inconsiderable difficulty.
Yes, the difficulties are not insuperable, and one can well imagine another family who perhaps given different circumstances choose to overcome those difficulties, and it's quite easy to think of ways in which the family might do that. You could put in place some different arrangements for childcare, for collecting and delivering from school. In this particular case, it is said that one of the factors is that AP's mother won't travel there alone, so she has to go with his brother. That's an entirely personal frailty on her part, if we may respectfully say so. Another family may not have that difficulty. The controlled person's mother or father may be perfectly happy to go and travel during the week on their own and go and visit him to maintain the social contact. And these are matters which are elements of pure choice that do not change the character of the package of obligations that have been imposed by the control order.
Mr. Tam, what was the object of this particular condition in moving AP 150 miles or whatever it was from his home?
It was to make it more difficult for AP to be in contact with his terrorism related associates.
Yes, and did it not equally make it more difficult for him to be in contact with his family and friends?
We accept that that is one of the consequences, but the relocation has different effects on different kinds of relationships. It's quite obvious that if you're a member of the family, the only thing involved is the actual travel to that particular place. An individual's contacts with his terrorist associates might be conducted in a different way, and so relocating him to another place may actually place more obstacles in the way of those contacts than they do in the way of overt contacts with members of the family. But anyway,
are you really saying that when you impose one of these control orders involving somebody living a certain distance away, that one can, or the Secretary of State can, expect not only that the individual concerned should adapt his way of life, but that members of the family should also, are under some sort of an obligation to adapt their way of life as well?
We don't, with respect, say that they're under an obligation to do that, but they are free to choose to do that if they wish, and whether or not they take up the opportunity to do that, and the way in which they take up the opportunity will ultimately be a matter for them.
Well, was this point all argued before Mr. Justice Keith?
Lord, not in this form and not with this degree of focus.
Because these are all matters of evidence, really, aren't they? I mean, it's all very well that he said, the judge said that his mother had never left London alone. And it might be a bit much to require somebody who'd never left London, no doubt for good reason, ever left London again. Now you're saying well, it's perfectly reasonable for her to leave London go miles and miles away. I mean, it strikes me as very strange, especially if it wasn't covered in the evidence.
Yes. But, Lord, it is the reason that we draw attention to this is because the question of whether a package of obligations constitutes a deprivation of liberty is a different exercise, as Lord has pointed out, from assessing, for example, whether there's an unjustified and disproportionate interference with Article 8 rights and obligations. And the case law about Article 5 has stressed throughout that it should be objective. As Lord Bingham put it in JJ, you look at the impact on a person in the situation of the person who is subject to these measures.
So that involves looking at what sort of family he has, what the family can do, what he can't do. I mean, he might not have had a family.
Well,
if you have a very elderly mother who could come and see you every week, but who couldn't travel to Scotland, where the Secretary of State decided to send you, say, well, that would be an irrelevant circumstance, would it? It wouldn't be an idiosyncratic choice, that, would it? It would only be a choice driven by infirmity. Would that be an idiosyncratic choice in your lexicon?
If one were to move the individual to a place where it became impossible for family to visit, for example, going back to the facts of Goodsardi, where the place in question was an isolated island off an island, with serious restrictions on the ability of anybody to get there to visit the person in question, to visit Mr. Goodsardi. When you get to a situation like that, when everyone would find it difficult to go and visit, then obviously that is something to be taken into account, as indeed the Strasbourg court did in the case of Goodsardi. But the Goodsardi is in fact an illustration of why those particular special factors ended up being decisive there, because when the same restrictions were imposed on Mr. Goodsardi, but in a different place on the Italian mainland, the Commission said that his application on Article 5 grounds was inadmissible, and it never even joined up with the main case. So it was only in those very particular and special circumstances where the island, which was in fact largely a prison anyway, had perhaps many of the qualities of an open prison for Mr. Goodsardi, who wasn't technically inside it. And any person would have found it difficult to get there. But where we're talking about an individual who's only been moved an hour and 3/4 away from London
With
to a place.
respect, it's a pretty big only. I have members of my family who live in London and other members of my family who live rather closer than that, and the difference in the occasions on which I see them is quite enormous.
Well, conversely, one might also point to the fact that for some people, an hour and 3/4 by train is daily commuting. So it's far from impossible to do it. And as the judge himself recognised, these are not insuperable difficulties. And the fact that his mother and the children had not been at all, and his brother had only been twice, ultimately, on the facts of this case, boils down to a matter of choice.
Well, you said that many times. Was there any evidence before the judge as to what the train fare is, even at cheap rates, for the mother, the brother, and 3 children? I mean, we are not talking about prosperous people here.
No, there was evidence, and there was evidence about the cost, and that is why the judge himself made the observation at the end of paragraph 88 on page 56 of the appendix. Sorry. Thank you. About travelling at off-peak times to get the advantage of lower fares. Learned friend asked to draw attention to page 183. Paragraph 22 gives some numbers. Which gives the background to the judge's observation about being able to get lower fares if they travel at different times.
You keep emphasising the need to adopt an objective approach. Isn't it right that the person whose position one needs to be looked at objectively is the controllee, AP? Do you accept that? It's his objective situation that has to be looked at, isn't it?
It is, and it's the impact of the package of obligations
on him.
A person in his situation. And I use those words advisedly because this comes from the Lord Bingham's speech in JJ. If your lordships take Authorities Volume 1, at tab 5, and go to paragraph 15, Lord Bingham says, continuous house arrest may reasonably be regarded as resembling, save as to the place of confinement, conventional modes of imprisonment or detention. The court has made clear that deprivation of liberty may take numerous forms other than classic detention in prison or strict arrest. The variety of such forms is being increased by developments in legal standards and attitudes, and the Convention must be interpreted in light of notions prevailing in a democratic state. What has to be considered is a concrete situation of the particular individual. Thus, the task of the court is to assess the impact of the measures in question on a person in the situation of the person subject to them. The Strasbourg court has been true to this guiding principle.
I know, but he then goes on to refer to Engel, which actually indicates what he's there referring to. I mean, Engel's all about disciplining people in the services, and you treat them as people in the services. It's a category distinct from the civilian, and they expect tougher sanctions and so forth as disciplinary penalties. I mean, that's surely the point, isn't it? I mean, that's as far as that point goes. He's not saying you look at Mr. X, who has a regular contact with his family for all the world, as if he's the same as Mr. Y, who frankly is delighted to be 150 miles away.
Well, with respect, the statement by Lord Bingham there is set out as a general principle. He could have used the words to assess the impact of the measures on the individual or on that person. But what he says is the impact of the measures in question on a person in the situation of the person.
That's right, that's in the situation of a soldier as opposed to a civilian, but it doesn't carry the point any further than that. That's how it strikes me.
I mean, the first sentence that you read out surely is the crucial one, the concrete situation of the particular individual. And one's looking, isn't one, at the objective situation, the objective impact of the measures on, in this case, AP. And the objective impact on AP is that because of the circumstances of his mother, he doesn't see her. I mean, is it more complicated than that?
With respect, it is, because of one needs to look closely at the reasons why his mother doesn't see him and why the children don't go to visit.
But why is that relevant to his objective situation?
Because if one is looking at matters which are truly objective as opposed to matters of choice, then you should disregard the things which you should disregard the things which are purely matters of choice because they cannot be truly described as objective. For example, if you had two hypothetical people who are subject to the same measures as AP. And one of them, AP is one of them, but the other one has a family where the mother is prepared to say, well, I want to go and see my son to make sure that he has some human contact, so I will get my friends, my neighbours, to take the children to school and collect the children from school one day a week, and I will go and visit him, and I'm quite happy to go on the train by myself, and so on and so forth. We respectfully pose this question. Why should that make all the difference between whether or not the controlled person, the two people side by side, have or have not been deprived of their liberty? And why should that make all the difference as to whether or not the Secretary of State has power under the statute to impose that particular package of obligations on the individual? We respectfully say that matters which are ultimately matters of individual choice ought not to have that effect, because otherwise...
His individual choice included taking out his nephews and nieces to the park. He can't do that anymore.
That's because his mother and his brother choose not to take them.
No, it's because he's not allowed to go there. Isn't it?
Well, with respect to...
Isn't there a restriction on how far he can travel?
There is a restriction on how far he can travel, but there was a restriction on how far he could travel when he was located in North London.
Yes, but when he was in North London, he could go and take these children to the park.
Only if his mother or his brother were prepared to travel to see him there, because he wasn't living at home.
I'm having difficulty with this concept of individual choice. If you take the detainee himself, he can choose, not this case, he can choose whether he wants to see his family or not. But that doesn't seem to be the sort of choice you're talking about.
No,
because if it is, then your submission has to be, well, his family situation is totally irrelevant because he could choose to see his family or he could choose not to see his family.
Indeed. Well, if the individual chose not to see his family, we say that's the classic example of an individual choice, which ought not to affect the question of whether he has been deprived of his liberty.
Yes, but I mean, you say that there is a choice. He can choose to see his family, he can choose not to see his family. It's probably me not understanding you, but on your choices theory, since there is a choice, that's subjective, and you could ignore the family. Whether he chooses, he wants to see them or not, is subjective, and you can ignore the family. At the moment, to my mind at least, your submission is leading in that direction.
What we say is this, that where the package of obligations gives him the opportunity to see his family, then that is the situation which must be taken into account when considering the question, does this package deprive him of his liberty? The fact that whether it's on his side or the family's side, they choose not to avail themselves of this opportunity should not, as a matter of principle, affect the question of whether he has been deprived of his liberty. Because if it were otherwise, if those matters could affect that question, then we would be in this somewhat absurd situation, we would respectfully say, in which the question of whether there's a deprivation of liberty and whether the Secretary of State has power under the statute to impose this particular package of obligations might vary between yes and no, depending, for example, on whether it's school holidays or term time, or whether the childminder is ill in one particular week, or whether the car has broken down, or, for that matter, whether the members of the family have spent all their savings on a new washing machine, which was very urgent, so that they can't afford the train fare to go and see the individual. Those are all factors which we respectfully say are not the sort of objective factors which the courts have had in mind when looking at the question of whether there has been a deprivation of liberty or not. It ought in principle, we say, to be possible to see whether or not there has been a deprivation of liberty by looking at the package of measures. So, for example, the core element...
You'd have to know who his family was, wouldn't you? You can't just look at the measures. You've got to find out whether he's got a family. You've got to find out the nature of the family. There are all sorts of things you've got to find out.
One ought to be able to do that, but these are objectively and easily verifiable facts which one can look at, put them all together, and then you have a package which you can assess following Guzzardi and all the other Strasbourg cases. But in the case of the difficulties which AP has experienced, none of these things could actually be known in advance when the Secretary of State draws up the package of obligations and says, well, I think you need to be an hour and 3/4 away from London by train, but it's not so far away that your family can't come and visit you. And even in North London, they were only visiting him a couple of times a week anyway. It wasn't like he was living at home and having day-to-day contact with them. But how is the Secretary of State to know in advance whether or not the individuals whether members of the family are going to go once a week, twice a week? How could it be known in advance whether or not they will make some adjustment to their lifestyle in order to make some...
Well, what does he assume? Does he make any assumptions?
Well, the Secretary of State makes sure that all these things are feasible and entirely possible for the individuals.
Supposing you've got children, he's got nephews and nieces, and supposing that what actually in practice happens is that on their way home from playing football or something on a Saturday, they call in on their uncle for an hour and then go on their way. That's a very easy thing to do. Children probably don't mind doing that and quite happy to do it. Quite a different thing if they're going to be put onto a train and taken all the way up to the unnamed town and all the way back again, thereby losing their entire Saturday on this expedition. Now, I'd have thought that on Sunday, I thought one could see there's an enormous difference between those two phenomena. Does one take, does the Secretary of State just not think about that at all?
The distance and the travelling time involved is obviously something which is going to be the same for everyone. And so that can be taken into account. But that was...
You expect children, does the Secretary of State expect their nephews and nieces to adjust their lifestyle in that way? It's a very big, it's imposing a big sort of obligation on them, isn't it?
Well, but can I perhaps to take the court through some of the facts, because I was going to put all of this into a factual context in the facts of this case to show you just how narrow a factual point it was that made all the difference for Mr. Justice Keith as to whether or not there had or had not been a deprivation of liberty. The AP was somebody who had been living in the UK until May of 2005, it was then that he travelled to Somalia.
Where is this most conveniently set out?
This is, well, I can give you perhaps I can give you the paragraph numbers from Mr. Justice Keith's judgment. If you go to page 31 in the appendix, paragraph 12 is the date of travel to Somalia, May 2005. Paragraph 13, in the middle of the paragraph, you'll see September 2005, which is when he went from Somalia to Ethiopia via Dubai. He then remained in Ethiopia for 15 months, which you'll see in paragraph 14, and then he decided to return to the UK in December 2006. You'll see halfway through the paragraph that at that point he was excluded from the United Kingdom, but nevertheless arrived. So on arrival, he was then detained under immigration legislation. Paragraph 16, he remained in immigration detention until July of 2007. In March 2007, he had been granted bail subject to stringent conditions as a matter of principle, but the release wasn't until July because the National Asylum Support Service had to take that long to find him accommodation that was suitable. He was then released on bail to that accommodation in North London and subject to the stringent conditions of SIAC bail. And at paragraph 17, Mr. Justice Keith describes the control order obligations, but can I draw attention to paragraph 18, where the relatively small differences between the SIAC bail conditions and the control order obligations are set out. So this is a man who, from the time of his release from detention in July 2007, had been subject to very similar restrictions on where he could go, what he could do, and who he could see, although in the last respect, you'll see the variations or the difference that was made set out in the second half of paragraph 18. So the point to be made about
that, you can impose restrictions that do amount to a restriction on.
Indeed, and that's not contentious. But the point is this: that first of all, that he, when he was in North London, he was not at home in any sense of the word, and he was not living in the area of London where his family live. So they had to travel to North London to go and see him in any event.
From where?
In south or southwest London. And so that was the situation that had pertained since July of 2005. And second, that with the restrictions that had already been imposed on him, he was already under pretty substantial social isolation in his North London address. So the starting point here was not that he was at home in constant communication with his family. And you have seen the description at paragraph 87 of how, in those circumstances, the family would come and visit him about twice a week. The children he would see once a week. And this was going to involve a journey to see him on any view.
I find it rather difficult to reconcile paragraph 17 of the judgment with paragraph 87. In paragraph 17, once the control order is imposed, even while he's in Tottenham, he could not arrange to meet anyone outside the flat apart from his mother and that brother, unless given permission, or attend any prearranged meetings or gatherings.
Yes.
His mother and one of his brothers were permitted to visit him. It's not very easy to reconcile that with 87, is it?
Well, the visits from his mother and his brother,
That's all right, yes.
and the children are those which were being permitted essentially by the exceptions. That his mother and his brother could visit without having to get permission in advance. And ditto with exceptions for those aged 16 or under.
I'm afraid I'm not quite following why we're looking at all this detail. There's no challenge to the judge's, as it were, assessment on the facts. You started on this course in answer to, I think, one of my Lord's questions, which wasn't directed to the history or the facts at all. So why are we looking at all this?
If your Lordship would bear with me, because I'm then going to come and to the point, the factual point on which Mr. Justice Keith's judgment turned, but to set that into a proper factual context. So that is the extent of the social contact that AP had. This was not with respect to question of the kids dropping in on their way back from school every day. These were outings that had to be made to North London, although admittedly it was a shorter distance for them to come. And then, although he sets out there the factual history of what happened after the move, and then at 88, he points out that although there are practical difficulties, those difficulties are not insuperable, and the family could visit AP in his new location by the means that the judge suggests. And it's in that context that I ask the court to look at paragraph 97.
Paragraph 97.
97, because that is the ultimate decision on the Article 5 point. Combination of the equivalent of house arrest up to the 16-hour point and the equivalent of internal exile, which makes AP so socially isolated during the relatively few hours in the day when he is not under house arrest, coupled with his inability to make even social arrangements because pre-arranged meetings other than with his mother and brother are prohibited, which lead me to conclude that the obligations imposed on him fall on the side of the line which involves the deprivation of liberty rather than the restriction of movement. Had he remained in London, as Justice Keith says, so that he could still see and be visited by his mother, his brother and his sister's 3 children, my view would have been different. So it is simply the fact that they were not in fact visiting him in his new location, which was making all the difference between the package of obligations amounting to a deprivation of liberty or not amounting to a deprivation of liberty. But as the Court of Appeal pointed out, the literal reading of he could still see and be visited by is clearly at variance with the judge's finding that they could go and see him, but in fact they were not doing so because they were choosing not to do so. They found it too difficult. And that is the sole point on which Mr. Justice Keith's view turned. And we respectfully say that if that is right, then that is in fact opening the door to all of the consequences which I'd identified before. Supposing the it were not a case of the individual being 150 miles away, but perhaps 50 miles away or 30 miles away, slightly further than the difference between the South West London home and the North London place where he had been since July 2007. And the family simply say, well, we're just not going to go. It's just a bit too far. If one looks at the individual's objective situation, he is not being visited there either. But we respectfully say, well, in that event, the question of whether there has been a deprivation of liberty and whether the Secretary of State has power under the statute to make this order is all depending on the choices of the individual's family as to whether or not they're going to bother to go over and see him. And that is the nature of the factual distinction which made all the difference for Mr. Justice Keith.
Are you saying that paragraphs 88 and 97 are, 87 and 88 on the one hand, and 97 on the other, are mutually inconsistent?
What we say is this.
Presumably you have to give some common sense to Mr. Justice Keith. When he wrote paragraph 97, he'd only just written paragraph 80, whatever
Yes,
it was.
yes, and
That's a reasonable inference, so it doesn't necessarily follow.
I see the force of learned friend's submission that one shouldn't expect the judge to have immediately forgotten what he'd just written.
Right. So you have to read paragraph 97 in the context of what he said before.
There are two ways of looking at this. One of them is that if you do take paragraph 97 at face value and look at its literal meaning, it is inconsistent with what he'd said in paragraph 88. And that is the third point that we make in our printed case. The only way of making those two paragraphs stand together consistently is by reading so that he could still see and be visited by as referring only to the actual state of affairs, that is to say, so that he would in fact be being visited by. And that brings us right back to the question of why is he not? And if it's not a question of ability, and there's not a question of insuperable difficulty, then, as we say, it is a matter of the family's choice, and it is a type of choice which should not make the difference between something being a deprivation of liberty and not being a deprivation of liberty. It is, in fact, the kind of choice which is impossible to predict in advance. One simply could not know in advance what this family were going to do, and you couldn't very well ask them because you know exactly what answer you'll get.
Are you saying that the fact that it was that there was, according to the judge, a considerable practical difficulty or considerable practical difficulties in visiting him is irrelevant?
There are difficulties which would be experienced by any person or the family of any person who had been moved such a distance. Those difficulties, that is sheer distance, the fact that it will take time and so on, those are matters which can be taken into account. I don't seek to depart from that. But there are choices involved here because these, or choices and if we can use the term personal frailties involved here, which are not those which would be experienced by anybody or any family in this position. And it is those choices and frailties which we respectfully say should not be taken into account because they are too volatile, they are too unpredictable, and they are not objective in the way that the Strasbourg domestic case law enjoins the court to be when assessing whether there has been a deprivation of liberty.
When the Secretary of State makes the choice or decides that this person should be sent to this place 100 and whatever miles away it is, does the Secretary of State assume that the relatives will visit? In other words, that the person will have that alleviation of his or her social isolation? Does it assume that or not assume that? Or what does the Secretary of State do?
What the Secretary of State does is to make sure that where the person is located, it is perfectly feasible for the relatives to go and visit. Yes.
And then, it being possible, the Secretary of State assumes that Does he? Or
After that, with respect, it's a matter of choice for the individual and his family as to whether or not to take up the opportunity. As I say, obviously, if we took AP and put him on one of the Outer Hebrides, then one couldn't take that same view. Anybody will find it difficult to go out there to visit the individual because of the distance, the time, all those practical things which apply to everybody. But what the Secretary of State does is he's looking for a place which is not so far as to amount to that sort of obstacle, so that the family are free to go and visit if they wish to do so, and the Secretary of State then leaves it as a matter of choice to the individuals as to whether or not they do so. If they choose not to do so, we respectfully say that's not something that weighs against the Secretary of State when deciding whether there's been a deprivation of liberty.
Do you say that Mr. Fitzgerald's point, which if I understand it correctly, is that he accepts that an unreasonable choice can be ignored because it doesn't flow from the control order? As I understand you, you're saying it doesn't matter whether the choice is reasonable or unreasonable. You just don't take it into account.
If it is a matter of choice, then it is to be disregarded. Obviously, we accept, just like learned friend is driven to accept that there are some choices which have to be disregarded. We accept that if the objectively assessed practical difficulties are so great as to amount to an obstacle, then obviously they have to be taken into account. But where you have
when you say obstacle, do you mean a complete obstacle, making it impossible, or just very difficult, or
impossible, or so difficult that that everyone would find that difficulty,
but not impossible?
Perhaps not theoretically impossible.
Well, then, if it's difficult but not impossible, somebody's going to have to choose whether, despite it being difficult, nevertheless it should be done, or alternatively, because it's difficult, the choice is not to do it.
The nature of the nature of the options that are open to the individual flow from the very fact of the location of that particular controlled person. So obviously they are part and parcel of those difficulties. But we're not in that territory here. We're in the territory of someone who is not that far away and is easily visitable if you make the appropriate arrangements. That's how the Secretary of State looks at it.
Sorry to interrupt you, but looking at the judge's finding, it is that there are considerable practical difficulties of visiting him. Are you seeking to go behind that?
I don't seek to go behind that, but that sentence doesn't stand on its own, because he does go on to point out that, notwithstanding that they hadn't in fact done it, the difficulties are not insuperable, and there are things that the family can do that would make a visit practicable.
You wouldn't really expect these 3 children, for example, to go every week. It couldn't have been an enormous disruption, the whole family's life, to go from South London off to this place every week. I mean, just think of the impact that had. It'd be a major, major change. Do you really expect that? Would one really expect that to happen?
Well, Lord, we respectfully say that when the place is an hour and 3/4 away by train, that is something that is perfectly possible for the family to do.
Imagine the children's reaction to every week, every Sunday being dragged off to that place. I mean, nobody would expect that to carry on indefinitely, would they, Mr. Tan? Imagine it. Another Sunday, oh gosh, we're off up there again.
Well,
it'd be quite a family palaver, I think.
But one has to recall that even when there was a palaver to go to North London, it was a palaver that was undertaken.
Yeah, one thing.
We don't actually know where they were going from, do we?
Address in southwest London, we can check to make sure that the address we have is still the correct one. But just have a moment. South or southwest London, perhaps one might describe it as sort of inner city, southwest London.
Could I just put this to you also? It does seem to me that you are really dissecting the judge's judgment to an extent which it's rather hard to justify. He'd looked at the effect of the move in the round, the hardship of not seeing family, and then 89, having said that, there's unquestionably another significant hardship, because he's isolated from his mosque, his people of his own background. Then we have, it is the combination of the equivalent of house arrest up to maximum period and the equivalent of internal exile which makes him so socially isolated during the relevant few hours, and so on. And then he throws in, of course, if he'd remained in London, and where he'd have been able to see his family, that would be different. But to suggest that the judge was deliberately saying the only relevant part of the social isolation was the family, and if that had been solved, the rest wouldn't have mattered, is going a bit far, isn't it?
We don't say that that was the only thing, but we do point to it having clearly been the decisive factor. And if that is a decisive factor, then we respectfully say that we are in the territory where the question of the existence of the Secretary of State's power to impose a particular package of obligations may evaporate, as I say, come the beginning of school term. If the family are happy to visit during school holidays but don't want to do it during term time, or evaporate if the car has broken down. And we respectfully say that that is a sort of person-specific factor which, as a matter of principle, because of these difficulties, ought not to be part of the assessment of whether there's been a deprivation of liberty. And if one then looks at the Strasbourg cases and indeed the domestic cases, one can't see any trace of the courts taking into account factors like that, even in cases where they could have done. They are looking at factors which can be objectively assessed, factors which are the same for everybody in the position of the person who is subject to that package of measures. And perhaps if I could return to that after the short
adjourn until 2 o'clock.